Good afternoon, everyone. Well, after all of today's deliberations, I've been asked to reflect on whether international refugee law will still be relevant by 2033. Questions about the future of international refugee law have been asked almost since its inception. The first Universal Refugee Treaty, the 1951 Convention relating to the status of refugees, originally limited protection to refugees who'd fled as a result of events occurring before the 1st of January 1951, although the drafters of the treaty did express the hope that it would have value as an example exceeding its contractual scope and would be applied to other refugees as well. For the first 5 decades of the Refugee Convention's existence, UNHCR's mandate was limited to 5-year terms, which were renewed successively until the General Assembly decided in 2003 to make UNHCR's mandate permanent, or at least until the refugee problem is solved. Despite political attacks, heightened border controls, and increasing numbers of people on the move, the international refugee regime, both in its legal and institutional forms, has proven to be resilient. And there's every reason to believe that it will remain so. This morning, Arathi queried whether our 20th century frameworks can tackle 21st century challenges. Well, I think the foundational principles of international refugee law are timeless, stemming as they do from centuries-old notions of sanctuary and shelter. And especially in light of some of the predictions we've heard today about future drivers and trends of displacement, their importance will only increase in the coming years, not diminish. But here's the rub. While international refugee law will remain relevant, the question is whether it will be able to do the work it was cut out to do. Will people be able to access territory to claim asylum? If they can, will they have access to legal status determination procedures? Will those procedures be sufficiently rigorous and nuanced to capture the complexity of movement and the compounding nature of risk? Will decision makers, especially if they're not human, be able to understand how multiple drivers of movement intersect and coalesce and how they relate back to core protective principles? And will the public be open to accepting those in need of protection? Will they be sufficiently well informed about why we should? It's here that our vision becomes less than 2020. If we look back to history, we can see that refugee law has been remarkably robust. Although drafted in the 50s, the Refugee Convention has proven itself to be adaptable to changing contexts and to be capable of a flexible and dynamic interpretation. So to give just one example, the refugee definition is now understood as being able to encompass gender-based persecution, or persecution in the context of climate change and disasters, circumstances that its drafters would never have envisaged. While international refugee law on its own can't resolve the displacement we see today or are likely to see in the future, it does offer a principled, ordered framework for protection, which can serve both as the essential premise for international involvement and the measure of accountability for particular actions or policies. Still, as my colleague Guy Goodwin-Gill has noted, the law alone does not provide solutions, and much remains to be done. One question is what future exists for international refugee law as opposed to national iterations of it. Rather than using the Refugee Convention as a blueprint to guide positive action, some countries look for the grey areas to confine and restrict their obligations as far as is arguably possible. I would say that Australia led the way on this by creating what it called a self-contained statutory framework, largely devoid of references to the Refugee Convention. In 2014, the then Immigration Minister, Scott Morrison, said, "This Parliament should decide what our obligations are under these conventions, not those who seek to direct us otherwise from places outside this country." There's a further question about how far refugee law will take us when there are many other people also in need of protection. The development of the principle of non-refoulement, non-removal, in human rights law is an obvious complement, extending protection to people who face a real risk to their life or, for example, who face the prospect of torture or other cruel, inhuman, or degrading treatment or punishment. Now, this has particular relevance in the context of climate change, with international bodies already recognising that without robust national and international efforts, the effects of climate change may expose people to a violation of their rights that would give rise to other countries' non-refoulement obligations. Given the unlikelihood of governments adopting new binding instruments to protect those on the move, the precise scope and contours of the principle of non-refoulement will become ever more important. Indeed, one of the most significant developments over the last decade has been our growing understanding about how climate change intersects with other drivers of displacement in the way that it amplifies risks and vulnerabilities. Some people fleeing the impacts of disasters and climate change will be refugees within the meaning of the 1951 Convention, because disasters can make a risk of persecution more acute. They can also exacerbate existing patterns of discrimination or marginalisation. There'll be other people who won't satisfy all the elements of the refugee definition, but who may still be protected by human rights law because their life or the dire situation they face on return means that it would be unlawful for governments to remove them. We go into these issues in a lot of detail in the Kaldor Centre Principles on Climate Mobility, which we released last week, and I believe there are copies there for you today if you wish to take a look. People who move because of the impacts of climate change and disasters will never cross an international border, but will stay within their own country. And indeed, over the coming decades, many more people may be trapped and unable to move at all. Whereas historically we've tended to view displacement as a sign of vulnerability, in some cases, immobility may be an even stronger indicator of vulnerability and risk, particularly if people's predicament remains unseen by policymakers. So how the world deals with those who are stuck may present an even greater humanitarian challenge than assisting those who are on the move. The vast majority of the world's population cannot lawfully cross a border. Most people don't have passports, which means visas are also inaccessible. Some passports obviously enable far greater access than others, which entrenches a global mobility divide. Projections about the use of artificial intelligence and other technologies may embed this even further. The Janus-based nature of biometrics and predictive analytics means that they can be harnessed in all sorts of ways, some positive, some negative. AI can assist with the provision of humanitarian assistance, for instance, but it may also subvert free and informed consent. And by way of illustration, refugees in Jordan who had to have their irises scanned in order to receive weekly rations felt that they had no alternative but to comply. As Louis said this morning, certain biases inherent in algorithmic profiling mean that difference is rendered as a threat. And yet at the same time, we were told that machine-assisted decision-making may be able to provide more nuanced approaches to uncertainty than human decision-makers can. Smartphones and social media can help those on the move to access and share vital information, to receive assistance, to stay in touch with family, and to be powerful global advocates. But again, these innovations can also make people more vulnerable to government surveillance and detection. So to what extent will access to territory affect access to solutions? As my colleague Fleur Johns has written, it may be that automation allows international institutions to anticipate and temper violence and suffering like never before. Yet the very same challenges may threaten to undermine international laws and international institutions' operations, or narrow their effective jurisdiction insofar as they heighten inequalities, magnify distrust, and impede communication and connection. As Neve mentioned earlier this afternoon too, we already have the technological capacity to forecast risks. So how can we ensure that this is used to anticipate and protect rather than to intercept and deflect? People who can access territory and can access refugee status determination procedures, automated decision-making poses further challenges. Even the best analytical models are only as good as the historical data that they're trained on. And there's a risk that machines will take too blunt an approach and deny protection to people in need, undermining both human rights and due process. In part, this goes to system design, which depends on human input and the values underpinning it, as we've heard. And as Shaya said earlier today, perhaps a better focus would be on how we can use assistive technology as a tool for human decision makers. In the asylum context, beyond the obvious concerns about wrongful denial of protection claims, there's a related issue about the ongoing development of refugee law. If decisions about people's legal status are made without full human deliberation, the capacity to develop more nuanced understandings of key principles and concepts may be lost. And with this, the notion of refugee law as a living, dynamic body of practice. For instance, our initial understandings about the impacts of climate change on displacement were not nearly as fully formed as they are now. And so had we programmed a machine early on, we may well have screened out deserving claims because of our own human fallibility in properly understanding the issues. And yet on the flip side, machine learning is now enabling major advances to our understandings. Next generation approaches to modelling climate mobility at a global scale use advanced statistical methods that are designed to accommodate the complex relationship between climatic factors and human movement. While the results are not yet at a point where they can reliably inform future policy, some interesting findings are already emerging. For instance, large-scale studies to date reveal that in impoverished communities, adverse climatic changes tend to affect migration only weakly or even negatively, reflecting resource constraints that compromise people's ability to move. So this is contrary to the common assumption that those in the most difficult circumstances will be the first to leave. All these considerations come at a time when communities around the world are feeling the pressures of shrinking resources, rising costs, worsening disasters, and the existential threat of climate change. Even those in relatively privileged circumstances may not feel particularly fortunate. The plight of others further afield may not be in plain sight. And if it does come into view as people seek protection elsewhere, then, as our last panel explored, the reception that awaits them remains unclear. The combination of global megatrends we've discussed today could either engender a new humanitarianism and communitarianism, or instead lead to hardened nationalism and xenophobia. So reflecting on the panel that we just had now, how can we create a sense of connection rather than disconnection, a sense of shared humanity rather than difference? Notably, not a single government has ever withdrawn from the Refugee Convention, despite perennial protests about its ongoing utility and relevance. And even the most jingoistic politician must surely realise that without the Refugee Convention, there would be greater disorder in addressing global displacement. As Volker Turk, who is now the UN High Commissioner for Human Rights, once noted, departures from the fundamental principles of international refugee protection have neither reduced nor stalled refugee movements, but have resulted in ineffective management of large-scale influxes, the diversion of refugee movements, and the creation of tensions between states as burdens and costs are shifted from some onto others. To foretell the future accurately requires a crystal ball, but to foresee it in general terms requires at least a solid understanding of the past. As Magdalena said this morning, we cannot deal with the future unless we acknowledge what has gone before. It is in taking this long view of international refugee law that I feel confident in saying that there is no doubt that international refugee law will still be relevant in 10 years' time. Whether it will remain sufficiently dynamic, living, and nimble in its responses to evolving circumstances will depend on scholars, decision makers, policymakers, and lawyers constantly demonstrating its adaptability and applicability in the same way as has occurred over the past century, as well as, of course, displaced people themselves explaining how a range of factors have combined to force them to move. There are certain patterns and trends that are likely to continue, but there will also be some disruption. Anticipating and planning for this is key. And of course, refugee law alone is not and never has been the answer. It is one element, albeit a very important element, in a complex of protective principles and other laws, policies, and practices concerning mobility. So international refugee law will not look identical in 2033 as in 2023. And I say that with some trepidation, knowing that we will have a fifth edition of the Refugee in International Law to write this coming decade. However, the fundamental principles on which international refugee law is based will remain, and some may even be extended in yet unanticipated ways, especially as we continue to scrutinise the outer limits of the principle of non-refoulement when it comes to protecting those at risk. So my hope is that 10 years from now, I will safely be able to misquote Mark Twain to assert that reports of the death of international refugee law were greatly exaggerated. Thank you very much for your attention.